what concern do you have about Mr. Falcone knowing that there's going to be a hearing so that if he wanted, he could file a media request?
All rise, please. The First Judicial District Court, Department 2 is now in session. The Honorable James C. Wilson, presiding.
Good morning. Please be seated. This is 20 OC 164, Eggleston versus Clark County Department of Family Services. This is time set for hearing on an order to show cause. Ms. Gorman, can you hear me okay?
It's Ms. Quinlan. Ms. Dorman's unable to join us today.
I'm sorry, thank you. Are you able to hear me okay?
I am, thank you.
Where are you located today?
I am in Las Vegas in my office in Clark County.
Ms. Paola?
Armeni, Your Honor. I am also in Las Vegas in my office.
And you're able to hear me okay?
I am.
This is being recorded on the court's recording system. Mr. Busby is present in the courtroom are you?
Alexander Falcone.
Falcone, okay. They are both present in the courtroom. I indicated in the order allowing Mr. Falcone to film. Are you filming?
Yes.
Okay. That I don't see a way to make a decision in this case without a careful review of the records. I wasn't expecting Clark County to produce any witnesses. As I said in the order, we contacted them for the sole purpose of finding out if they had or were intending to call witnesses, and the answer was no. Mr. Busby, I'll start with you.
Thank you, Your Honor. We're appearing today on a narrow issue. Most of the relief that we requested in our motion to unseal has already been granted by the court pursuant to its August 5th, 2022 order. We appreciate the court's order on that issue. My client provides coverage of numerous proceedings in Nevada via video, and he tries to provide continuing coverage throughout the length of proceedings. This matter has related proceedings going on in Vegas, and he tries to catch every recording. He's only able to do that insofar as he's able to submit media requests in a timely manner in accordance with SCR 230. The only issue that we asked the court to address for us today is that there's no way for him in this matter, if things are filed under seal, such as orders scheduling hearings, there's no way for him to know that those hearings are going to happen such that he can submit a timely media request. So we just ask that, and I realize that the way things work in this jurisdiction are a little different. There's no central online indices where you can just review those things. So we would ask that the court impose some sort of mechanism such that my client can receive timely notice of when hearings are scheduled, such that he can submit requests to provide coverage in accordance with SCR 230. That's something he's been unable to do today. And we think that could take place either through an order to the parties, providing that he be noticed when the hearing is scheduled, or some sort of order to the court clerk indicating that he be able to access those records. That may be a little bit more complicated than just providing notice in this case, but we just wanted to bring that issue to the court's attention and ask for limited relief on that basis.
Are you not receiving notice on everything?
Your Honor, I don't believe he will insofar as...
I mean you personally.
I have insofar as we've kind of inserted ourselves into this proceeding by virtue of the pleadings related to what's happened with the media request. But beyond that, I don't think that there's a continuing requirement that I be served under Rule 5, because we're not a party in this case. We haven't sought intervention. We're just participating in the rubric that's provided under SCR 230.
Ms. Quinlan?
And Your Honor, I think that the department's position at this point is pretty much addressed in the order that you issued yesterday. This proceeding is kind of different than most proceedings that would be filed in court, in so much as it's a petition for judicial review. So it functions basically as an appeal. So our concern is that the briefs that we would be filing in this matter pertain to nothing but the confidential record, the report, the investigation. That's the center of the controversy at this stage. So those things, as you ordered yesterday, should remain sealed so that to preserve that confidentiality. If we move to an oral argument after briefing in this review petition and our Nevada judges want to record it, the problem there is that the argument's going to be based off the briefs, which are, again, based off that confidential information. So, in so much that the confidential information is being disclosed, and it's not just Mr. Eggleston, it's the other parent in the matter, medical information, HIPAA-protected information, information regarding minors. So it makes it more complicated to follow, basically, and if I understand the argument that Mr. Busby just made, to kind of follow the story that's going on in the judicial, this is not a continuation of that, and there are many things that are going on in that case that are not germane or pertain or have anything to do with your judicial review of a hearing master's decision, which is what is the heart of the controversy for this case. So we just feel that moving forward, the paper should remain sealed as you ordered, the briefing should be sealed, and I guess any argument would need to be sealed if it's based on this confidential information. I'm not sure how to parse that out from any legal analysis that wouldn't involve that information.
I think the request currently would be just for notice of the hearing, period. What concern do you have about Mr. Falcone knowing that there's going to be a hearing so that if he wanted, he could file a media request, which the court would then, the parties would have an opportunity to respond and the court would make a decision?
If we have an opportunity to respond to a media request, should it be granted, then, or should it be considered or filed, then we don't have, I just don't understand the mechanism of how that would work. We don't have a position on him being able to receive notice of a future hearing.
And I think that's what Mr. Busby's requesting, is an order that what the court files, what the parties file, as far as a notice of a hearing, which can be a hearing is set for this, that's all that has to go in that, the notice that would need to be provided to Mr. Falcone. There doesn't need to be a description about details about what's going to go on in the hearing and those things. I'm not seeing a particular burden or a concern there myself. The protective mechanism is, this isn't a carte blanche that Mr. Falcone would be able to record everything. It would give him notice so he can file the request. You would be able, and the other parties would be able to respond, and the court would make a decision. So I'm sorry, I interrupted you. Go ahead.
No, that's fine, Judge. And I concur basically with what you're saying. I would just ask that we could possibly, if there's a notice of hearing, maybe someone could email us to Mr. Busby if we already have his contact information. Because he's right. There's no way for him to independently find a notice of hearing due to the system. So
I guess I inferred that you're not going to continue representing him in this case, in the judicial review case. Is that correct, or do you want them to send a notice to you?
Your Honor, sending a notice to me works or directly to Mr. Falcone. I represent him on a continuing basis, so it's likely, hopefully I'll remain doing so for some time. But if both Mr. Falcone and I can be notified by email, that would be sufficient. Insofar as he's able to submit a timely request under SCR 230, there's very strict timelines he has to follow, so that's the only caveat to that.
Your Honor, may I be heard on this?
Absolutely.
And Your Honor, generally, I have no opposition, and that's why we filed a non-opposition. I certainly believe that Mr. Falcone or any media should have access to our courtrooms. However, I am a bit concerned about putting the onus on the attorneys to notify the media when things are going on. If I understood your order that we received a couple weeks ago, the docket has been unsealed. So as a result of that, anything that's filed, whether it's sealed or unsealed, I think the court is still, and I may be wrong on this, so if I'm wrong, I apologize. But even if something is filed under seal, I'm assuming that the name of the document would still be on the docket, as well as if the hearing. Would your docket show in your district when a hearing is set? Because if so, then I think that should be on, if the media is interested in the case, they have access to the docket instead of putting the onus on the parties or even the court to affirmatively advise them as to what's going on in this case. I mean, that's not done in any cases. And I can't imagine in any district in the state of Nevada where the onus is on the attorneys or the court to reach out and advise the media when something is going to be on the calendar.
The docket would show that there's something to do with the hearing. Does it have the hearing date?
If there's a notice of hearing filed, it will have it in the docket.
Mr. Busby, I'll let you respond. Mr. Busby is correct that what that would require Mr. Falcone to do is have someone check very regularly, because a notice could be filed 10 days before the hearing. So I think that's their concern, but I'll let him speak for himself. Go ahead.
That is, Your Honor, and I've practiced here, so I'm familiar with the court's routines and practices, and oftentimes a hearing will be scheduled along with or contained in an order granting or denying some substantive issue in a case. So there isn't always a notice of hearing that's separately filed that would be obvious to a non-party that this hearing is going to occur. And that's the same in the Second Judicial District and other districts. If it would please the court, if a requirement, an order could be entered that a notice be issued, either by the clerk of the court or the parties in the case where a hearing is scheduled, and that we be copied on that notice via mail or some other mechanism. I do understand Mr. Murphy's technical concern with the onus being put on the parties to provide notice. That's not typically something that's done, but this is an unusual circumstance. I guess, to address that technicality, our option would be to file for limited intervention in the case under a solid line of cases, and for requesting notification, as part of that limited intervener status. But that seems to be a bit sacrificing, the good for the perfect. If there's some way that we can be provided notice by the clerk or the parties, either would satisfy us without having to, go through those technical machinations, which we don't think are really necessary.
But she does bring up a point. If I do it in this case, I have to do it in every case, don't I?
This case is unique in that it's the sealing status is based on an amalgam of statutory requirements, which I don't think you see in every case. Typically, Mr. Falcone is able to access public records such that he can tell what's going on in the case. And so it's easy for him to just do all of this on his own. But because of the nature of just how this court happens to process scheduling hearings and the way the dockets are kept, and the fact that they're not online, makes it technically difficult for Mr. Falcone, such that as a practical matter, he may miss out on being able to submit an SCR 230 hearing. So that's the only thing we're trying to address here. We don't think you have to do it in every case. This case is unique and different, and so we're not asking you to venture into rulemaking here. And our request is based on the particularities of this proceeding, not a general problem that you face in these types of cases when Mr. Falcone is trying to provide coverage.
Ms. Armeni?
Your Honor, I don't think my position has changed. Again, overall, I'm not opposing this. I think they absolutely should have access in this case, in any case, just as a general proposition. I'm hesitant on the onus on the parties. That's my concern, is that now we have another obligation to make sure that we're letting them know, and I just don't want something to fall through the cracks, not intentionally, just because they're not a party of the case and we're not thinking about it.
Ms. Quinlan, did you have anything to add based on what's gone on since you spoke?
I would just join with Ms. Armeni's concern, because who would provide that notice and how to do that does pose a problem.
Your Honor, I've just received a little bit of clarification. My client has no issue calling the clerk of the court every Monday, for example, to see if something's been scheduled for the week, but to date, that information hasn't been disclosed to him. It's been refused. That may be the case because if something's scheduled in a substantive order, like I mentioned, the clerk may not have the discretion to understand a requirement to disclose in that case. So if that could be clarified, I think that could resolve the issue of the onus back on our Nevada judges to call weekly and see if something's been scheduled. And perhaps some technical clarification, just something as simple as requiring that the parties issue a written notice of a hearing when it's scheduled, separate from any substantive order. That, I think, would do the trick as well. And frankly, we're just looking for the simplest and least costly and most efficient way to get our SCR 230 requests filed when it needs to be. Anything that works for the court that accomplishes that goal would work for us.
If Mr. Falcone called the clerk's office, I'm speaking with Vanessa Allegria, the clerk that is present with me in the courtroom. If Mr. Falcone called and wanted to know if a hearing had been set, unless the order title indicated that a hearing had been set, the clerk's not going to know.
Well, this case is filed confidential, so I'm thinking that that's probably where the problem is coming. They're not releasing information because it's considered a confidential case. And he's not a party to the case, so that's probably why they're denying that.
I'm going to need to give it some thought. I'm not ready to make a decision on that this morning. What about and Ms. Armeni, I'll start with you. Is there a way, other than having somebody thoroughly review the administrative record to determine what should or should not be disclosed, if anything?
I'm not sure that there is, because I think it's intertwined, and I think that the documents can be redacted so that the majority of the substance could be provided in the public record while protecting the confidentiality of some of the information that's in the documents. But I don't know, without somebody looking at it, frankly, Your Honor, I'm not sure how that gets accomplished.
I'm not sure what the briefs would say or what witnesses would be able to tell me. I mean, it seems the record is the record. What do you think about having a senior judge or a senior justice appointed as the problem I have is if you want me to do that review, I will do it, but it will be sometime next year. I do not have time, especially with the elections stuff, to do it. What do you think about having a senior judge or senior justice appointed as a master?
I have no opposition to that.
Mr. Busby?
No opposition here, Your Honor.
Ms. Quinlan?
I don't have an opposition to having someone appointed to do it. I would hope that this case could wrap up before next year. So that's the only way it's going to get done.
It is. Unfortunately, it is. I am not very familiar with senior judges or justices in the Las Vegas area. We have some pretty experienced former family court judges, so would have more familiarity with 432B cases, I think. Judge Linda Gardner, Senior Judge Linda Gardner, Senior Judge Francis Doherty, Senior Judge Weller, can't think of his first name off the top of my head. If you have other names, I'm not sure what Senior Justice Seda, Douglas, or Gibbons are doing. Well, that's going to be after the first of the year. Do you have any names you'd like to recommend, Ms. Armeni?
No, Your Honor, I will defer to your judgment.
Mr. Busby?
Your Honor, any of the justices or judges you mentioned would be suitable and fine for us.
Ms. Quinlan?
I agree.
Well, the next question would be their availability. So what I will do is I'm looking at a list of the senior judges and justices. I think what I would do, the way that works is we make a request to the administrative office of the court. They are the ones that appoint the senior judge or justice. The list that I currently have, I think I would include Senior Judge Deborah Schumacher, Senior Judge Linda Gardner, Senior Judge Francis Doherty to the AOC and let them figure out who schedule-wise would be able to do it sooner rather than later. And I think I understood all of you to say that you didn't have any problems with any of those names. I guess I just want to, and I hadn't mentioned Schumacher, so I want to confirm that you do not have an objection to any of those. Ms. Armeni?
No, Your Honor, I do not.
Mr. Busby?
No, Your Honor, thank you.
Ms. Quinlan?
I do not have an objection to any of those things.
We'll make that request today. It normally takes several days, and we've got a holiday coming up, for AOC to be able to contact them, find out what their schedule is, give them an idea of what the assignment is. So we will make that request today. We'll inform all of you as soon as we know anything from the AOC. Is there anything else, Ms. Armeni, that you'd like to try and accomplish while we're together today?
Yes, Your Honor, in fact, I do. Can I just get one point of clarification as to what the court is going to request right now of the assistance of a justice or another judge? Is that to go back and look at the documents that have been previously filed, as well as moving forward as to what documents perhaps the one judges can receive? I'm just trying to understand the scope of what they're going to be reviewing.
I hadn't considered the future documents, but I think that's a good point. My thought would be that they would review those and try to make a decision about if something can be redacted and make the rest of it available, if there may be things that are entirely available. My review of it, like I said, was cursory. I was trying to get a flavor for the case. And then the master would make a recommendation to the court. The court then would be in touch with all of you to receive objections or non-objections to the master's recommendation. That's what I had envisioned.
Okay, thank you. And then my second, Your Honor, since I do have at least Ms. Quinlan here in the court here, looking at the docket that I was able to see, it is an older docket, but it appears that the petition was filed, and the court understands that I come into this case late, so all these filings occurred before I was involved in the matter. But it's my understanding that a petition was filed in this case, then the DA's office filed a motion to dismiss the petition. There was a motion to stay pending the Supreme Court ruling, and then it appears that Mr. Eggleston filed a reply to the opposition to the motion to dismiss. So I'm not sure. I'm trying to figure out if the court's going to rule on the motion to dismiss, and then we can get, depending on what the court does, of course, we can get a scheduling order for the rest of the briefing schedule.
The petition was filed back in November of 2020.
Yes, Your Honor, it was that on November 17th. It looks like the state filed their motion to dismiss the petition on January 13th of 2021. And then Mr. Eggleston filed a reply to the opposition of the motion to dismiss on February 9th of 2021.
I don't
And
see,
then there's no,
go ahead.
no, I'm sorry, and then, it appears to be not much activity, at least on the docket I have. There's not much activity probably because that's when the case is at the Supreme Court.
I don't see that an order staying the proceedings. I have, I'm looking at tabs on the pleadings and papers, not a docket, but I'm not seeing that an order to stay was entered. I'm not seeing actually that an order on the motion to dismiss. This isn't uncommon when we deal with not the right phrase, when we have attorneys from Clark County, because we do not receive motions until there's a request to submit filed. So it's not uncommon to have attorneys that aren't familiar with our local rules file motions, but nothing happens court-wise because there is no request to submit. I'm not sure if that's the case here or not. I'm not saying that happened. I'm just saying that frequently that is the answer to the riddle of why nothing has happened on the motion. So I don't, ask me your question again.
That's fair, Your Honor. Perhaps maybe I can make the request of Ms. Quinlan, if they'll submit a request to submit on that motion so the court can make a decision on the motion to dismiss, because depending on if the court grants the motion to dismiss, then I think we're pretty much done with this court. If the court denies it, then my request would be that there would be some sort of briefing schedule put in place so that we can continue on with the petition for judicial review.
All right. Mr. Busby, what about, first of all, my idea of on how the master, what they heard, they're all female, what her duties would be, how that would work?
Insofar as the master would be able to inform my client of any pending scheduled hearings such that he could submit an SCR 230 request, that would satisfy what we've requested today. If the scope of it moved beyond that to reviewing documents for confidentiality to determine whether or not they could be released to Mr. Falcone, we think that's a great idea. That would expand the scope of the public access insofar as it's permitted under the rules and ensure a thorough review that in fact does occur. We think it's a great idea.
Ms. Quinlan?
Our position is that the documents are going to be all confidential. So if the court orders a hearing master or a senior judge to review them, our position would just remain that there's nothing that can be released, as long as we have an opportunity to oppose any recommendation should they want to release or not redact information that would be confidential. I'll leave it there. Regarding Mr. Armeni's request for a request to submit, I can have that done and mailed into the court so that we can get moving on this case moving. If that's what takes to move the case forward, then I would like to do that.
All right. I would like for you to be sure that you're familiar with at least some of our local rules. In addition to the request to submit, the local rules require a proposed order be submitted with every motion, every opposition. If there's a reply, the replying party can file an amended, it wouldn't be entitled amended, but they can amend their proposed order and submit that. There are certain things that the proposed order should contain, which are the facts, the law, the conclusions of law, and what the order is, as opposed to saying motion granted or motion denied. There are page limit to motions. So I'm just requesting that you be familiar with the First Judicial's local rules. Ms. Armeni, I'm going to ask if you would please prepare an order after hearing indicating that the court is going to consider the request of Mr. Falcone on how we can provide notice, again, with understanding that he would then, if he wanted to file a request, would have time to file a media request. The parties would have an opportunity to respond. The court would rule that the parties did not object to the court appointing a court master, including Senior Judge Schumacher, Senior Judge Linda Gardner, Senior Judge Francis Doherty, to review present and future filings, to see if those are confidential, not confidential, partially confidential. The master would then make a recommendation to the court that would be provided to the parties for their input, and the court would make a decision. Was there anything else, Ms. Armeni, you think should be in this order?
So, Your Honor, just to make sure I understand, number one is the court's going to consider the request of Mr. Falcone on how they could be provided notice of the hearing so that they can participate and file their documentation in good time. That's number one. Number two is that the parties don't object to a court master to review past, present, and future filings. And I'm sorry, Your Honor, it was Schumacher, Gardner, and who was the third judge?
Doherty.
Doherty.
And when I make that request to the AOC, I'm going to indicate to them that the basis of this is a 432B case. So they, I believe, had some kind of specialties in the Second Judicial. So I'm not sure, one of these may be more qualified or at least more experienced with 432B cases than the others, and that would be my preference.
I'll prepare the order and I'll run it by Ms. Quinlan and Mr. Busby, just to make sure I didn't miss anything before I submit it to the court.
Thank you very much. Ms. Quinlan, anything else?
No, Your Honor.
Mr. Busby?
Nothing, Your Honor, thank you.
All right, thank you all. I'm going to adjourn the hearing, and do you have an idea when you would be running that order by the other attorneys? I'm not pressing you, I just, if I don't put something on my calendar, things to drop off of my radar.
I appreciate that, Your Honor. I'm a deadline person myself. If I can have a week, I'll try and get it to them sooner.
That would be just fine. To save time, if you want to email that to my judicial assistant, we can print it here, so there won't be a delay in mail and those things.
Okay, I can certainly do that. Thank you.
All right. Thank you again. Court is adjourned. Thank you.